Hi, this is Mini Gautam. I am the founder and owner of Arthavat Law Offices, and we specialize in corporate, commercial, financial, and especially startup law. So, recently we have been working a lot with startups and have advised many startups on investments, transactions, their day to day commercial contracts. And today I will be speaking on some key points to consider while drafting commercial contracts for startups, both from the lawyer's perspective and also from the startup's perspective. What are the things that need to be kept in mind while signing, while executing contracts with a for the startup? Now, just like any commercially run business or organization, startups also need to be very mindful about the contracts that they are entering into, because a contract is a legal obligation. So any commercial contract, any business contract that a startup is entering into, it is very important to identify what are the obligations that will be cast on the startup and how long those obligations will continue. So, starting from incorporation, whether it is the startup is a partnership firm or a limited liability partnership or say a private limited company, it does not matter what is the kind of legal entity that the startup is. But it is going to be imperative that in the day to day running of the business, there will be various arrangements, there will be various issues that arise, and for the operations of the organization, there will be need of entering into various contracts. So starting from whether all the partners together, they need to have an understanding between them as to what are the rights, what are the responsibilities of each partner, what is the exit mechanism if a partner wants to leave. So there a co-founders agreement comes in handy. And we have seen with a lot of startups which do not enter into these written contracts, it becomes a very tricky situation if one of those issues arises and it has not been clearly spelled out and defined in the form of a legally binding document, how that situation would be addressed. So, say the shares have been divided between the co founders, but there's nothing in writing. And tomorrow, if a founder wants to leave, then what is the treatment of the shares going to be? Can he buy back his own shares? Do the shares go back to the company? Do they go to the other co founders? If nothing is written, then it is going to be a very tricky situation and it will result in huge legal costs and expenses when this matter goes to court. So that is why these kind of written understandings, the written contracts are very important. Very often we have clients who come to us with a simple purchase order. They will say we have everything written on this purchase order, on this invoice, and all the terms and conditions are captured. And what we find is that those purchase orders, those invoices, they don't have the legal clauses written down properly, so they are not adequate, they don't cover all the scenarios. So again, taking another example, suppose a startup is in a business where they need to procure material, they need to procure some kind of raw material. Now they don't have it in writing when the material will be delivered, what is the penalty for late delivery, what is the interest that will be calculated, what happens, how is the inspection of the material done, what are the acceptance criteria. Only when a proper commercial contract is entered into are all these points covered and included in the contract, that there will be, it will become completely unambiguous and there will be less scope for litigation in future. Similarly, you have the scope for contracts everywhere. So when you hire employees, when you hire consultants, again, many startups say that okay, we give them a basic appointment letter which probably just has designation and salary. Again, there could be a host of issues which arise in this scenario as well. If an employee wants to exit, how much notice period does the employee need to give? Non compete is a huge issue. So nowadays, with the whole the whole hype about moonlighting, why has it happened? Because employment contracts very often don't clearly specify that the arrangement is exclusive, or what are the restrictions on the employment, or what happens if you are working in some other kind of a role for profit separately while doing your job. So these scenarios are hardly ever covered, and that is why commercial contracts are so important, because you need to capture all these things very categorically. You enter into a lease for your office space, and there the lease agreement is very important, because very often a lease will have a period during which, a lock-in period in which you cannot exit, you cannot leave the office. There's a penalty if you do that. Your security deposit will be forfeited. So it is very important to have these kind of arrangements captured everywhere. For all these arrangements with your business partners, you want to enter into a new domain. So for example, you are, say, a cloud kitchen, you are, or say, a restaurant business service provider. Now you want to enlist your services on, you want to offer your products on on Swiggy, on Zomato. So there also you need to have some kind of an understanding, some kind of a written arrangement. You want to, so anything that you do which is a part of your business, as an ongoing part of your business, you need to have your contracts in place. You're getting a new investment. Every investment in a startup starts with a term sheet, and the term sheet very clearly defines what are the terms of financing going to be, what are the terms of investment going to be, what is the role of the promoters going to be in future, how much is the funding coming in, what are the terms and conditions of the funding. Because when somebody is giving money into a startup, it will be based on certain terms and conditions. There will be certain business operations that the startup needs to continue while the funding is being completed, and the shareholding pattern changes. So all these things, they come in the contracts. Also, some of the legal clauses are very important, and they need to be paid attention to, like indemnity. Indemnity is when you agree to make good a loss for another party, and almost every contract has an indemnity clause. But wherever you are agreeing to indemnity, in a sense you are agreeing to a financial liability. So indemnity, liquidated damages, penalties, anywhere where you agree to make a payment to the other party, it is very important to pay attention to these clauses, because this is where the liability comes in, and this is where you will be, maybe after, there's a scope for litigation. Because anywhere where you are required to make some kind of compensation, that is where there will be litigation. Another very important clause in all contracts is the dispute resolution clause. So, say you are sitting in Delhi, but the other party is sitting in Bombay, and they have put in the clause for dispute resolution in Bombay. It could be arbitration, it could be the court procedure, no matter what it is. If it is in Bombay, you will have to travel there, you will have to bear legal expenses there. Whereas, of course, in your own city, in your own home state, it becomes much easier to manage the legal procedure, to from the administrative perspective, from a cost perspective. So definitely pay attention to these clauses. And another big mistake I think many startups do is that they don't get it vetted by a lawyer. They try to, any simple arrangement, anybody you're speaking to about your business, is very important to have an NDA in place, a non-disclosure agreement, so that you have it written down and specified that whatever you have shared is completely confidential, and that the other party is not permitted to disclose that information apart from for the purposes specifically for which you're sharing the information. So it's very important to have a lawyer on board, or at least consult a lawyer before sharing any information, before onboarding employees. Have the agreements and contracts in place, any business commercial arrangement, any discussion with investors, everything must be properly articulated, written down, all the scenarios captured, and only then must you enter into any arrangement. So definitely have the appropriate legal consultation in place. Uh, Thank you. And if there are any other queries, we can be reached out.